God save the Commonwealth of Massachusetts. The vote is now open. Please be seated.
Morning, Ms. Allen. Mr. Cooper, you may proceed.
Good morning, Your Honors. May it please the Court, Howard Cooper for the defendants, appellees in this case, the Boston Society of New Jerusalem, Boston View Corporation, Edward MacKenzie, and Thomas Kennedy. Your Honors, the December 2nd, 2004 decision of the trial court, Judge Brady, in this matter, correctly and clearly concluded that Article 10, Section 3 of the Boston Society's bylaws, which are entitled dissolution, meant and mean just what the plain ambiguous language of that bylaw states, namely that the assets of my client are to be held in escrow by the appellants, the General Convention, only and solely if the Boston Society of the New Jerusalem, quote, shall cease to exist. In other words, it dissolves. In that event, as the bylaw makes clear, and only in that event, the assets of my client would be held in escrow by the General Convention for 20 years to establish another Swedenborgian church, or if that didn't happen, after 20 years, would revert to the convention, and this is important, quote, with any restrictions on uses which may have been voted by the society at the time of dissolution. Thus, the bylaw specifically envisions a vote of dissolution in order for it to be triggered. The word dissolution under Massachusetts law permits no ambiguity. My client is a charitable religious organization organized under 501c3 of the Federal Tax Code, and under Massachusetts law, it's governed by General Laws Chapter 180, including Section 11, which provides specifically for the sole mechanism by which a public charity can be dissolved. Chapter 180, Section 11A, actually sets out dissolution procedures, using that word, dissolution. This provides for the winding up of affairs of a public charity. The procedures include a vote to dissolve by a majority of the board of directors and a petition to this court, the Supreme Judicial Court of Massachusetts, setting forth the substance of the grounds of the application for dissolution and requesting the court to authorize the administration of its funds such that the charitable purpose, as the court may determine, may continue. That statute concludes with the following language. The provisions of this section shall constitute the sole method for the voluntary dissolution of any such charitable corporation. It is undisputed.
Mr. Cooper, can I ask you a question? When can we take context and history into account, even if the language is unambiguous, or can we take context and history into account?
May I address those separately, Your Honor, because I think that the decisional law of this court and the appeals court does so. Context is important, but the context here is a bylaw provision that is entitled dissolution, and the court need go no further because the context is provided. In fact, there's nothing in these bylaws that says the headings are not to be given any weight or meaning.
I was going to say sometimes we don't give the meaning in statutory context.
It doesn't say that here. In terms of history, Your Honor, I would fit that within the rubric of generalized extrinsic evidence or parole evidence, since the word history would encompass everything that happened prior. And in that instance, Your Honor, I would submit the law is very clear that such evidence can be considered, but not for the purpose of contradicting the plain language of the provision at issue. Bylaws, after all, and I don't think there's very much disagreement between the parties as to what the applicable legal standards here. Bylaws of a church, even a charitable organization, are a contract between the church and its members. The interpretation of bylaws is governed by contract principles. The issue of whether a contract term is ambiguous is a question of law for the court. The words have to be interpreted in accordance with their plain and usual meaning in context. And most importantly, ambiguity is not created just because there's a controversy between the parties, each side favoring their own interpretation of what the words might say.
Mr.
This
Cook?
might seem like a technical question, but it could be important because perhaps the judge below should have waited for summary judgment, not saying one way or the other, but it's possible. And I wonder, the plaintiffs suggest that their affidavit could be considered by the judge, but they don't. I didn't see that they cited any authority for the proposition that an affidavit is an exhibit attached to the complaint. And I wonder if you have anything to say on that subject, because that could be important.
I do, Justice Cowen. In this situation, in this context, the affidavit would not have been properly considered by the judge, and indeed the trial court judge did not consider it. On appeal, the appeals court, without really much discussion, simply cites some boilerplate law that matters that are a matter of public record can be considered by the court.
Well, you can consider them. That is to say, it's not if you're doing a 12b6, it's not impermissible to, as it were, lift the skirt. You can consider them, but you can't take them as having substantive meaning if they violate the parole rule. In other words, if there was an ambiguity, maybe summary judgment would be correct. Maybe you would have to wait for summary judgment. But if it was uncontested that there was, or provision was missing, one could, in some circumstances, consider it. But that doesn't answer the question here, whether or not it violates some other prohibition about what you cannot do when you're interpreting a bylaw.
I agree, Chief Justice Marshall, and I think that the Superior Court and the Appeals Court exercises and decisions in this case stand in stark contrast to each other. The Appeals Court, respectfully to the Appeals Court, giving it very short shrift, effectively started with the extrinsic evidence in order to create an ambiguity that it actually didn't even get to the point of defining or stating what other reasonable meaning the words were susceptible of. But the Appeals Court actually cited the Perry affidavit in order to come up with an ambiguity. The Superior Court decision respectfully conducted the correct analysis, which was to look at the words themselves, the heading, the words, the title of the paragraph in the bylaw, dissolution, to read the words, shall cease to exist, to read the last sentence that talks about and it clearly envisions a vote for dissolution, and determine these are plain and unambiguous words. If the drafters of this bylaw had meant disaffiliation, which is conceptually an opposite concept to ceasing to exist, in a disaffiliation, the church still exists. You couldn't come up with a more contradictory piece of evidence, and that is the exercise that is prohibited by the clearly established law.
Mr. Cooper, could you address Article 6 of the bylaws, which provides that the pastor of your client's church shall be in good standing on the roll of ministers of the General Convention?
Certainly, Your Honor. At the time the bylaws were adopted, my clients were affiliated with the General Convention. That's a matter of historic fact, as the Barker Court from California has said in a very similar circumstance. It's a mere statement of present intention memorializing the relationship. If you look at that very paragraph, though, Your Honor, you'll see in the provision that says about what happens when you're going to replace the pastor, it actually talks about two things you can do. You can go and look at the list of the Pastoral Search Committee of the General Convention, or you can go out and do it directly yourself. And very importantly, Your Honor, and I don't think that this is emphasized in our papers, but I'd like to emphasize it in this argument, Article 13 of the bylaws of the Boston Society provide for amendments. These were not fixed in stone. It says by any two-thirds vote, we can change anything in these bylaws. This is a congregational, not a hierarchical church. So my client, as a matter of First Amendment rights, has the absolute right to associate or not associate. Indeed, the plaintiff's arguments here in terms of trying to get past the plain and unambiguous meaning of the bylaw comes dangerously close to asking this court to become embroiled in matters of faith and administration within the church. The central thrust of this complaint, as both the Superior Court and Appeals Court recognized, was that certain individuals, defendants Kennedy and MacKenzie, had somehow taken control of the church and influenced votes and facilitated the admission of new members who didn't really believe in the Swedenborgian doctrine. Well, since that is the linchpin of everything they say, and indeed, despite the prohibition against a departure from doctrine argument under the First Amendment, that argument's actually made in the plaintiff's brief. But that is the gravamen of the case, and once you get past the plain language, or if the court improperly gets past the plain language, then you start having Mr. Perry, for example, describing, well, here's what we all really wanted to do, who we wanted to be affiliated with, et cetera. That leads us straight into problems under the First Amendment with prohibitions against judicial entanglement with the affairs of a religious institution. I would emphasize to this court, especially since it's just a stone's throw, a matter of feet from where we're currently located, that the Boston Society of New Jerusalem Church still exists at 140 Bowdoin Street. It's existed since the early 1800s. It's had its location on Beacon Hill for generations. It still holds services. It still has a pastor, the same pastor that it had before its vote for disaffiliation. It provides religious instruction in Swedenborgian doctrine. It continues to pursue its charitable mission. In short...
Can I interrupt you for a minute?
Certainly.
I don't want to take away all your time, but your time's running down. On the conversion claim, if you're going to get to that, I assume your position is fairly straightforward, that there's no standing.
Yes, Your Honor.
Either the General Convention or the other person.
The appeals court didn't explain what it had in mind in footnote 10 in keeping the conversion claim alive in this case, but for purposes of the standing issue, it is indistinguishable from counts 3 through 11, in which the court recognized that the Attorney General's office under Chapter 12, Section 8B through J had exclusive jurisdiction to police the affairs of this religious charity. I would note for the court, and I think the court can take notice of it, that on June 25th of 2007, the civil investigative demand action that had been filed was dismissed.
But there was a 2-year, wasn't there a 2-year?
I think it was 3 years, Your Honor.
Okay.
June 04 to June 07. And the consent judgment, by operation of its terms, expired on June 15th, 2007.
Okay.
I have to add,
Mr. Cooper,
Justice Brady.
can I ask you one about the conversion claim? I take it the property that is alleged to have been converted is the same property we're talking about.
It is, Your Honor.
Okay. It's not like the convention had provided some additional resources that they claim were now being converted. It's the same property of the Boston Society that's in dispute.
In Boston View Corporation,
Right.
which is also a defendant and appellee. I would add, Justice Graney and Justice Cordy, that there's a second argument that exists as to why Count 2 really can't go forward, and that's the same First Amendment argument that I alluded to earlier. Conversion, by definition and given its elements, presumes that the plaintiff will prove that there has been some type of wrongful exercise of control over property. The gravamen of the complaint and the amended complaint here again is that the control that came to pass, allegedly, was achieved by virtue of my client facilitating the new membership of people who were insincere in their belief in Swedenborgian doctrine. Again, even to analyze that claim would improperly enmesh a court in the private religious affairs of this charity.
Isn't there another argument? Maybe you don't make it, but if under the bylaw they didn't cease to exist, the parent church, or whatever you want to call it, General Convention, would have no right to any of the assets in any event.
That's correct, Your Honor.
Ergo, the individual member and so forth don't have standing.
Yes, that is the threshold argument.
So there's at least three arguments why that count should not survive. And footnote 10 is just a conclusory statement by the appeals court. There's
Again,
not much analysis there.
I agree, Your Honor, and it's difficult to understand how Count 2 can be differentiated.
I mean, it's just an Ipsy Dixit.
I would point out, Your Honors, in the few seconds I have left, that there are 3 states that have considered what we submit is identical language to the shall cease to exist language at issue in this bylaw: Ohio, New York, and Missouri, all considering a provision in the Book of Order of the Episcopal Presbyterian Church of the United States, which had the shall cease to exist language. And the courts in each of those decisions very clearly differentiated between a disaffiliation and a dissolution. A dissolution under each of those decisions took place only when the members had been dispersed and the religious purpose of the enterprise was over. Again, Your Honors need only walk down Bowdoin Street and you'll see that the church on the hill is still there.
Thank you, Mr. Cooper. Mr. Kulig?
Good morning, Your Honors, and may it please the Court, Lawrence Kulig, and with me is Damon Hart, and we are here on behalf of the General Convention of the New Jerusalem in the United States of America, together with the Massachusetts Association of the New Jerusalem. Your Honor, we would submit, Your Honors, that the case is actually very simple, and the appeals court did get it right. Fundamental question is whether under the bylaw provision of the local church, Article 10, Section 3, whether a vote of disaffiliation has given rise to a claim. Remember, we are on a motion to dismiss. Has given rise to a claim that the asset has been triggered and the assets belong to the national church, the General Convention. As the appeals court has noted...
If what you say is true, that you say particularly on page 39 of your brief about the efforts taken by efforts of loyal members of an affiliated church in 1989 to amend the local church's bylaws to insert provisions in Article 10 to specifically ensure that in the event of a takeover by a hostile group unaffiliated with the denomination and resulting disaffiliation, the local church's assets would be held by the General Convention. But if that's so, why isn't the word disaffiliate in the bylaw? Why is it cease to exist?
I would submit, Your Honor, to look at the 2 ambiguous phrases in the bylaw are, you have an undefined term, religious body. It's known as the Boston Society. It doesn't refer to a corporation. It doesn't refer to the corporate dissolution statute, anything like that. There's no reference to that. It talks about a religious body ceasing to exist. And it says if that religious body ceases to exist, the money will be held by the national church for the establishment of another, that's the word, another affiliated church.
Another suggests that the first one ceased to exist.
That's correct, that religious body ceased to exist. So how you have to look at those 2 phrases, religious body, undefined. What does religious body mean? You look then at the word, the creation or establishment of another affiliated church.
But the bylaw itself says the religious body known as, and here we have it, the Boston Society of New Jerusalem, Inc.
Correct.
I mean, that's the body. It's the corporate body. Correct?
It is, but there's no reference to dissolution. There's no reference to the corporate dissolution statute. That is, in fact, the name of the entity. There's no dispute about that.
It doesn't say become disaffiliated with the mother church.
We acknowledge that the word disaffiliate is not in the language in Article 10, Section 3. However, it is, and I think the Court is well aware with respect to the standard on a motion to dismiss under Rule 12b-6, as is alleged in the complaint, these bylaws were drafted not by lawyers. They were drafted by loyal church members at the time, and the facts at the time, in 1989 when they drafted this, was that, in fact, they were concerned about a disaffiliation. They were concerned, as is alleged in the complaint, that there was the General Church, a rival national Swedenborgian church, which was considering taking them over. And they put these, and this is why they drafted the bylaws. They may not have been as articulate as perhaps lawyers would have been, but this was done by loyal church members at the time.
So your position is that the disaffiliation is the same as dissolution?
What we're suggesting is that...
Are the words synonymous?
we're suggesting that it could very well be found by a trier of fact, based on the evidence, based on the testimony of the people who drafted it, as is recited in Mr. Perry's affidavit, that they use those words synonymously.
Well, can that
Cease to
affidavit
exist
be-
meant disaffiliation.
Affidavit be considered on a motion to dismiss? Do you have any authority that indicates that it can be?
We did. In fact, we cited in our brief, Your Honor, I believe it was the Quimby case versus Zoning Board of Appeals. I know it's cited in our brief, where the Supreme Judicial Court stated that in considering a 12b6 motion to dismiss, the court may look at all items that are in the record, the exhibits to the complaint, the other items that are in the record, to determine
But is
whether
an
that complaint
affidavit-
states a claim that entitles the party to relief.
But an exhibit, is that properly an exhibit to a complaint? An affidavit is not, I don't think it's usually considered that way.
What happened in this case, Your Honor, was the case was originally filed in the federal court. The complaint was filed together with an affidavit, together, I believe, was a motion for a preliminary injunction. The case was subsequently remanded to the state court, and that's why the affidavit is in the record, and it was in the record both before the trial court as well as obviously before the appeals court.
Why don't we just say that filing that affidavit converts this into a summary judgment? All right? Is that okay with you?
It is, Your Honor, because, in fact, what the affidavit does by Mr. Perry is confirms exactly what the allegations are in the complaint. Not legal conclusions. Factual affidavit stating that this is what was occurring at the time. We were concerned about a takeover and a disaffiliation, and therefore we put in Article 10. We talked about ceasing to exist and having the national church hold the money for the establishment of another denomination-affiliated church, which is consistent with what he was trying to do.
The fundamental question is whether this provision is ambiguous, correct?
It is.
And we apply ordinary contract rules to it.
Correct.
And if it's unambiguous, it doesn't make a whit of difference whether it was drafted by laymen or lawyers, or what these lay people may have thought they were doing, if it's unambiguous.
With respect to that, Your Honor, I think in order to get to whether it is or is not ambiguous, the court, and I could cite the various cases, but the court must construe the language in the context of when it was drafted, who drafted it, what the situation, the factual situation was, and what the intentions of the parties were when they drafted it. And as the court has stated, I believe it's in the Keating case, it's when you consider it in context like that, that terms which may not initially appear to be ambiguous, in fact, do become ambiguous when one considers the context in which those documents were drafted.
But isn't that often applied when the language doesn't appear to be ambiguous, but its application to a particular circumstance may be ambiguous? That's not this case, is it?
We would suggest that it is, Your Honor, and in fact that it does apply to this case. Because you do have, again, you go back to those two fundamental phrases that are undefined. Religious body. Why does it say religious body as opposed, why then it does talk about the Boston Society?
I take it this is still a religious body. It's still a religious body. Still known as the Boston Society of the New Jerusalem, although they use another non-corporate name as well, Church on the Hill.
Correct.
So I don't understand what you're getting at.
Because we're saying religious body is susceptible to different meanings, and it can mean something more than simply the corporate title of Boston Society. A religious body, to these laymen, could mean a church which is specifically affiliated with a national organization. And that religious body no longer does exist. That's undisputed.
Let me ask you this. The Swedenborgian churches, are there some that are not affiliated with the convention? I mean, is every Swedenborgian church in the United States affiliated with the convention?
Well, as I understand it, Your Honor, I don't want to misspeak, but as alleged in the complaint, there were rival Swedenborgian national churches.
Right.
Now, whether there are any other Swedenborgian churches that are unaffiliated with either the General Convention or the General Church, I just don't know, Your Honor. Those are the key terms we would submit, certainly at the present posture of the case. And in light of the Perry affidavit, in light of the factual allegations, not legal conclusions, but factual allegations that were in the complaint, the religious body has it ceased to exist. And we would submit that on the facts in the complaint, where you have a local religious body which has been affiliated for 2 centuries with a national church which prides itself in its own bylaws with all these provisions relating to the national church, that its pastor has to be on the roll of the national church, that it was the first local church to affiliate with the national church. Has that religious body ceased to exist when it's infiltrated by outsiders and it disaffiliates? And we would submit that that's a claim and it's a factual issue that needs to be decided by the trier of facts.
Mr. Kulik is...
Why would infiltration by outsiders mean that it ceases to exist?
Because it's...
Any effect on the corporate being?
Because it's no longer, we go back to the phrases I said, I underlined it, highlighted 100 times, religious body. It is no longer a religious body, an undefined term, because it's no longer affiliated with the church. And it's clear we would submit that that's why it talks about, in the event that occurs, the money is to go towards the establishment of another affiliated church. That word, another affiliated church, must have some bearing on what they meant by religious body.
Mr. Kulig, is Mr. Cooper correct that the pastor at the time of the attempted disaffiliation is the same person who is the pastor today?
It's our understanding that it is, Your Honor.
Okay.
Yes. With respect to the jurisdiction issue, Your Honor, that was raised, I would refer the court to your decision over the summer, the Maffey versus Roman Catholic Archdiocese Court, their Roman Catholic Archdiocese case. In that case, you had individual parishioners at St. James Church in Wellesley whose claim was that they had transferred property to the archdiocese. They claimed it was based on an oral agreement that had been breached. They claimed that they had an equitable reversionary interest in the property. And this court clearly found that they had standing, without talking about the other issues, whether there was a breach of contract, issues of fiduciary relations, with that issue of standing. It was the court held that there was standing for those individuals because they had a private, particular cause of action based on those facts, which was different than the general public interest in a nonprofit or a charity. And we would submit that that case, together with the Dartmouth College case we cite, are ample support for the fact.
But if we were to read the bylaw differently than you suggest, isn't that the end of the case? I mean, if the property, if the convention never had an interest in the property, how could they possibly have standing to allege that it was converted?
I would agree, Your Honor. If the court were to find that it was unambiguous, that no factual issue was raised at the present state in light of the evidence in the record, what's before the court, I would agree that the plaintiffs did not have standing to pursue those claims. That's correct.
Would it be an oversimplification? I want to make sure I understand your position. The church that's in the same location, that holds services each Sunday, that has the same pastor, that still pursues its charitable mission, your position is that's not the religious body that was envisioned when they discussed religious body.
That's correct. That's correct, because the religious body that was envisioned...
It may be a religious group, but it's not the religious body that was envisioned in the Bible.
That's exactly right. They could very well be a religious body that's a Muslim body, a Jewish congregation, but it wasn't the religious body that was envisioned by the drafters of this bylaw in 1989, where what they sought to do was to preserve it as a general convention affiliated church. And that's why they talk about the money being held by the general convention for the establishment of another general convention church.
Well, that money is to be held if the church ceases to exist. I mean, the argument is, of course, if it dissolves itself, the money's got to go somewhere. And it seems that since they're affiliated with the general convention, that makes perfect sense under the circumstances. But if it's not dissolved, continues to exist, that's a different story.
I respect and recognize the court's argument. As I said, I think that I recognize the court's argument. I believe that when the court considers it, as I said, you have to look at the bylaws in the context of all of that, one bylaw provision in context of the entirety of the bylaws, as well as, under the 12b6 standard, the factual setting, the context, the relationship of the parties, what they intended, and by the drafting of these bylaws. And as I said, this was done by laymen, not done by lawyers, in terms of the language that they used.
Mr. Kulig, as I understand the appeals court, it did not focus its attention on the religious body ambiguity, but only on the cease to exist, correct?
I believe that's correct, Your Honor. As I read their decision likewise, they focused on the cease to exist language as being susceptible of more than one meaning. I would submit to the court that that language also is ambiguous. To turn it around on my brother, if they wanted to say dissolve by statute such and such, they should have put that in. They used it later on. They might, which suggests, by using the word dissolution at the very end, but using the word cease to exist next to religious body, I would suggest that there's an ambiguity created there. Why otherwise would they have not used the word dissolution or referenced the corporate dissolution statute? That would suggest that there was something else intended by these lay people when they used religious body and right next to it talked about cease to exist.
Thank you, Mr. Kulig.
Thank you, Your Honors.